Good morning, everybody. It is now exactly 1 minute past 10 South African time. Welcome to this year's Lex-Informatica Conference. This year being held virtually, obviously due to the circumstances that we are having around the world currently. We're just waiting for the conference co-chair to connect. That is Dr. Mohamed Chawki. We were just having some gremlins there. But with that having been said, like I said, this is the 12th installation of the Lex-Informatica Conference. It's being held virtually. This year, we are celebrating what we call 20 years of African cyber. Right. So we are celebrating 20 years of cyber law in Africa. That meaning for the last 20 years, cyber law has actually been recognized in Africa as a discipline. It has been recognized as an area of the law that requires attention. And as we can see, the various African states have drafted various pieces of legislation dealing with aspects of cyber law. I'm not going to be talking too much myself in the introductory part because I don't want to take away much of the time. As you know, on this online platform, timing is everything. So we're going to have to keep quite strictly to the times allocated to the speakers and so forth. So let me just introduce the first speaker. Our first speaker will be Madam Sophie Kwasny. She is with the Council of Europe. She is the head of data protection unit there. She will be telling us about the European data protection, in particular Convention 108 plus. She's really a champion of that particular convention. I see Sophie has joined us. Morning, Sophie, how are you? Lovely. Sophie, your mic wasn't on. Is your mic on?
Yes. Can you hear me?
Yes. So,
good morning.
Wasting further any time, let me give over to you, Sophie, for the first presentation. Thank you.
I think your co-chair joined, so I don't know.
I see. Dr. Chawki, are you there? Okay, it looks like Dr. Chawki is here, but he's still connecting. I think his microphone is not on. Dr. Chawki, your mic? It's fine. Let's leave it at that. I think over to you, Sophie, and you can start with the presentation.
Okay, thank you very much, Sizwe. I thank both the co-chairs, Dr. Mohamed Chawki and you, Professor Sizwe Mtuze, for inviting me to this conference, Lex-Informatica, and very happy to start speaking about data protection. I've actually prepared a slide presentation, PowerPoint, that I will now try to share with you. Application, there you go. I hope it will be working. As I don't have the view to the platform, Sizwe, if you can just confirm that that the presentation is on and you can see it.
Yes, we can, Sophie. You may proceed.
Okay, perfect. Thank you very much. So indeed, I've been asked to speak about Convention 108 and 108 plus, and I think it's a perfect introduction to any data protection event, actually, because you will see that what I will be presenting today will be echoed throughout the day. I've seen that later Today you will be speaking about POPIA and economic development. You will see what the convention can bring in that respect. You will be speaking about security, data security breaches, legal challenges in the cloud with all the global concerns. And the convention is definitely one of the elements of replies for that. So a first important point to make, because in the data protection community and environment, everyone around the globe has heard about the GDPR, of course, but the GDPR has been adopted by the European Union, and despite the fact that the organization I'm working for, that is the Council of Europe, has the same flag, has the same anthem, we're actually very different organizations, and the instruments we're providing are also very different. To give you an illustration, the Council of Europe is based in France, and we have 47 member states. That includes Turkey, that includes Russia, to speak about the two big ones that are not EU member states. So the geographic scope is already going much beyond the EU. I could also now mention the United Kingdom, which is no longer EU country, but Council of Europe member state. And the root and the objective of the organization has always been to defend human rights, democracy, and rule of law. And we've been doing that for 70 years already. And so all the work we're doing, and it's the case with the data protection, is a work that is meant to really cement and strengthen human rights, democracy, and rule of law. So I think that's an important starting point to highlight. So I think on the program, it's mentioned keynote. I don't consider it to be a keynote. First, because we are all behind our screens in our offices, in our living rooms. I'm in a living room. I don't see you. I don't exchange with you. And the other thing is that I'm not in South Africa. I've never had a chance so far to come, so I want to formally contest for that, object to that. It's a pity. It's a pity to do it remotely. I would have loved to be with you. At the same time, it's true. It's enabling more participation, but also because we're a more intimate number of people, I think it can just be a conversation, and I would be very happy to respond also to any question you have. And there on the screen, you have pictures that were taken in Accra in June last year, and it was the first event or formal conference of the African Network of Data Protection Authorities, which was really a great event. And so I'm very pleased to speak to you also about what the convention means for Africa. So the presentation will be structured around those 3 points. First, what is the convention? But I will start with Convention 108, which is the historic instrument, and Convention 108 Plus. What can it bring to you, and how can its benefits be harvested? So let's start with what is it. Convention 108 is a treaty. It's an international legally binding instrument tackling data protection solely, and it's unique because there is no other treaty in the world. If I compare, for instance, with the Malabar Convention under the African Union remit is limited to members of the African Union. Here with Convention 108, it's open to any country in the world. So there is no geographic focus. Since the beginning, the drafters of the convention have wanted it to be a global instrument. It was born in Europe, but it's always been meant to apply to any country interested in that. The condition, of course, is that you need a complying data protection legislation matching the provisions. And throughout its 4 decades of existence, because we will be celebrating next year, 28th of January, the 40th anniversary of the convention, it's been highly influential. I've already mentioned the GDPR, and I will come back to it later. The GDPR is a derivation of Convention 108. There is, if you want, a common identity, common root, and the GDPR is what the EU member states that are also parties to the convention have decided to enact, to go one step or even two steps further than Convention 108. I highlight 28 January because it's the date that is worldwide celebrated as Data Protection Day or Data Privacy Day, and indeed it's the birth date of the convention. The convention, we refer to Convention 108, Convention 108 Plus, but I really want to highlight the full title of the convention. It's the Convention for the Protection of Individuals with regard to the processing of personal data. It's key. It's not about protecting data, it's about protecting persons. And that, through the years of application of the right to data protection, which is now an autonomous right, is very clear. The right to data protection is the right that is meant to serve as a means to protect and enjoy other fundamental rights. So where are we today with this convention? Convention 108, which is the 40 years old instrument, which is the text that is still in force as we speak, gathers 55 countries that have committed to respect its provisions. And as you can see, you have all 47 member states of the Council of Europe, plus non-European countries that have started acceding to it in the past 10 years, I would say. And you see it's more Latin America and African countries. So you have Argentina, Cabo Verde, Mauritius, Mexico, Morocco, Senegal, Tunisia, and Uruguay. Burkina Faso has been invited to accede to the convention, but has not yet finalized the accession procedure because they were waiting for the review of their national law. And on top of those 55 countries, the convention establishes a committee that enables to observer countries to join the work. And there you see with the observer countries, the list is actually quite long. We have over 70 countries coming to the meetings, and we have all regions of the world. You see Pacific countries, you see Asian countries, North American countries. So it's quite a diverse and rich mix of experts working together. And because data protection is of common global interest, it's very important. This is so the visual of the convention, both in terms of purple and the dark blue is observers. And it's a pity, as you can see, the Africa, we have more gray than because indeed, if I compare with the state of data protection in Africa, we have over 30 countries that have adopted data protection legislations, and a number of them are now working on that. I can tell you that even, for instance, if Sudan, if Gambia, if Namibia are gray now on this map, well, they are actually at the moment working on data protection legislation. So it's a pity that we have all this gray here for Africa. That means countries that are not either parties or observer engaged in the work in Strasbourg. And it's a pity because, as you can see, South Africa is in gray, despite the fact that there is a law, there is an authority. So let me come to 108 Plus now. What is it? In January 2011, when we celebrated the 30th anniversary of the convention, it was felt necessary to upgrade the text, to review it, because there were obvious new challenges linked to technologies, linked to increase of data flows. And so it took us 7 years, as you can see. It's quite a long time, but what is important to note is that in between those 7 years, one thing that happened was the revelations by Edward Snowden that really on the scene globally absolutely changed the game. Much more interest, much more awareness, much more dedication of some countries to ensure answers reported by Snowden would not continue. And the other thing that happened in the meantime of that period is that other institutions or international organizations also reworked their legal framework in data protection. For instance, it was the case of the OECD. The OECD privacy guidelines were reviewed in 2013. Case of the EU, which prepared its GDPR, that is the successor of a directive that was adopted in 1990. Developments into consideration, because if I only focus on bounds by the EU, by the convention, we had to ensure full compatibility between the instruments. I will now focus. One really states the role of the right to data protection. It's a right that contributes for the respect for other human rights and fundamental freedoms. That's what I was saying, and in particular the right to privacy, because it's traditionally attached to the right to privacy, but it's going beyond. What is a very strong value of Convention 108 and 108 Plus, because this has stayed, is that it applies fully horizontally to both public sector and private sector type processing. And if I can give you an example, Argentina obtained an adequacy decision from the European Union. It means that for the private sector types of data flows, Argentina obtained free flow of data with the EU. That's great. But with respect to the public sector type of processing, which has become of high importance with the Schrems II decision this summer, the convention is really providing at the international level a form of benchmark, of guarantee that the countries that are acceding are also applying strong data protection principles to that sector. So that's key. Something I would like to highlight is that if you look at the convention, it's a very small text. It's actually 20 articles if you compare to the 100 of the GDPR. So it's quite high level and general, and then it's for countries in their legislation to adapt. The root of core principles that apply to the processing are very straightforward, and definitely they will fully correspond to what you have in POPIA. So Article 5 is on the legitimacy of the data processing and quality of data, and there obviously you have the principle of proportionality, purpose specification, balancing the interests at stake, data minimization. What is also key is that if you want to process data, you can either rely on the consent, and when you rely on the consent as the legal basis, the consent has to be a very strong consent, so you have a number of conditions to match. But there are other legitimate bases laid down by law. So consent is not the only one, of course. And here, as you can see, it's general, but then it's in the law that the countries will say, okay, those other legitimate bases can be contract, can be vital interest, can be legal obligation, you name it, but here we're general. Another key provision of the convention, since the discrimination of the persons when they're being processed, need a strengthened protection. And so it's the provision on sensitive screen, what we have added to the original list of health data, transparency. So now we shift to the controllers and their obligations. And so they have a list of information to provide to ensure that the processing is fair and transparent. A core part of the convention is the rights to the data subject. We have not taken any of the 1981 rights off. We've only come and built on top of that. So the right to deletion always existed. The right to access always existed. Right of correction always existed and is maintained. And now we brought some new rights on top, which are aimed to respond to the fact that with algorithmic decision making, there is this fully automated chain of decision that can be made about us, and we need to put back the data subject, the persons, in a control mode of that chain. So those are new rights that are brought in the modernized convention. Article 10 of Convention 108 fully reflects the evolution of the right to data protection, with new obligations for the controller and processes. One is accountability, one is data protection impact assessment, privacy by design, privacy by default. You will see that you don't find any of those terms in the convention because they are branded terms, but the fact, for instance, of taking measures to comply with obligations and demonstrate this compliance is exactly what is accountability is. And so this, which was not in the original text, has been added and is a very strong reinforcement. As I was saying, Convention 108 and 108 Plus apply also to the public sector, but the right to data protection is not an absolute right. It has to wait against other interests, and there are possibilities for exceptions and restrictions, very precisely and strictly circumscribed. You can see there the conditions. Of course, you need a law, you need proportionality and necessity, and you need specific grounds, for instance, national security. What is important is that if the parties to Convention 108 Plus decide to derogate to some of the provisions, for instance, exempt their data protection authority from the oversight of the processing for national security, then they need to make sure that there is an effective and independent mechanism that exists elsewhere. And I really highlight this because this is the key of Schrems II, and Convention 108 Plus is one of the responses to Schrems II. The value of the convention, obviously, transborder data flows. It's this vision of a common zone of countries that have agreed to common principles, common definitions, rights, and commitments, and that can trust each other and that can let the data flow. When you transfer outside the parties, of course, there are means to secure an appropriate level of protection. It's exactly the same logic that exists with the GDPR. A core part of any data protection system is the enforcement, and it's the role of supervisory authorities. This is now strengthened in Convention 108 Plus, and so this is one of the core requirements. Also today, because we're all confronted with the same challenges. I'm using my phone with the same tools and interfaces than you, and we are facing the same difficulties. We need our regulators to be able to act internationally. The convention provides a legal basis to that cooperation, and that is also unique. So let me move to what can the convention bring to you, and I want to reassure you the first part was clearly the longest part, and you will see that now I only have a few minutes remaining. So as I said, we're in a world of ubiquitous data flows, flowing constantly across frontiers. We need mutual trust, we need cooperation, and this can only be achieved if commonly we respect principles and create this common legal space. So the more countries will come and join the convention, the more the operations at international level will be facilitated. Clearly, for those looking at the adequacy and the EU, I think it's important to mention the articulation between the EU framework and the convention. From an EU perspective, the convention contributes to a convergence, global convergence towards a set of high data protection standards. That's why the EU is promoting the convention. Here it was the chief of the private office of the President of the European Commission on Data Protection Day that highlighted that Convention 108 is the mother of the GDPR. It's rather the mother of the Directive of 95 and the grandmother of the GDPR, but clearly the articulation is there. You actually saw it very clearly in the 95 Directive. There was one recital that mentioned that this directive gave substance and amplified the principles of Convention 108. That's exactly the link between the frameworks. Now you see a reference to Convention 108 in the GDPR. in recital 105, that is the recital that deals with the transborder data flows and adequacy. So any country outside EU wishing to obtain an adequacy is considered in light of the international commitments it's taking, in particular Convention 108. And there you see at the bottom of my screen, I refer to Schrems 2 because I think that Schrems 2 has reinforced the value and has shed a new light on the value of Convention 108, 108 plus in the context of international data transfers. So how can the benefits of this convention be harvested by you? Well, first, I'd like to mention the work of the committee. I mentioned this committee is established by the convention. It meets in Strasbourg with over 70 countries. South Africa could participate as an observer in the committee. There is no obligation, no requirement. It's a great network of opportunities of exchanging with peers, of visibility at international level. And it gives direct access to shaping policies at international level, because the committee, what it's doing, and there I think it's of benefit for any of you interested in any of those topics. This is on our website. You can have access to it. The committee is really selecting challenges of the moment, topical, and working on it. On the left column, it's the topics we're working on at the moment, and you see it's very diverse. But digital identity, for instance, is a really, really important topic in Africa at the moment. On the right-hand side of the screen, you have the topics, the instruments that have already been adopted by the committee. And I can name others. I can name health data, I can name employment, and telecommunications. There are really a broad variety of topics that are being addressed, and it would be great to have more African participation in this work. And there I make the link, I'll come back to ACRA and the African Network of Data Protection Authorities. At the moment, we are organizing for the African Network a series of thematic workshops. That's also the beauty of this tough situation we're facing, is that we can engage remotely. And so all those topics I've mentioned, you see political campaigns, digital identity, are topics we are addressing directly with the network in a series of thematic workshops. So another step beyond this observer status, of course, could be to take ultimately the international commitment to accede to the convention. It is a convention that is absolutely complementary to the Malabar Convention. There again, the identity and the root is the same. From a South African perspective, for you as whether you're practitioners, academics, but really focusing on data protection, it can give an impetus to legislative developments, because a country that seeks accession needs to comply. So then there needs to be an adjustment of the legislation. And so it's necessarily a path towards progress and developments that are interesting for a country. And to conclude my presentation, starting from this instrument that was born in Europe, I want to highlight that because there is no equivalence, countries around the world that want to commit to a strong data protection framework have to accede to Convention 108+. And this is something that was actually highlighted by the Special Rapporteur on the Right to Privacy, Professor Kanatachi, that has called upon all UN member states to accede to Convention 108+. For those of you who want to know more about our work, I recommend this handbook that was published in 2018 jointly with the EU, actually. So it covers both the EU framework, the GDPR, the Police and Law and Judicial Cooperation Directive, the case law of the Luxembourg Court, so the Court of Justice of the European Union, but also everything that we're doing in Strasbourg, our convention, our recommendations, and the case law of our European Court of Human Rights. So it's a very rich handbook. You can find it online. And here you have all my details. You can email me if you have questions. You have the website that is indicated there, where you can find access to all the information and the instruments I've just mentioned. So I thank you very much for your attention.
Thank you very much, Sophie, for a lovely presentation and I think a brief overview of Convention 108 as well as 108 plus, also showing, you know, on an international scale, the necessity of the convention and maybe a possibility for South Africa to also become a signatory. We'll be giving some questions to the floor now. If there are any questions from the floor, you can, at this stage, put your hand up. Are there any questions to Sophie? Let's see. Well, until there are any further questions, I would like to ask a question. So if one were to become a state that wants to become a signatory, what is the process in becoming a member state in that? And I see there's also another question here, right? Is the pace of technological change too fast? Let me see. For regulatory authorities to keep up. So that is one comment. That's from Michael Patchett Joyce. So I think you can just comment on the two issues. My question on how to become a member state, and the question from Michael Patchett Joyce saying, is the pace of technology too fast for regulatory authorities?
Yes, thank you very much, Sizwe. Your question first, like for any international treaty, it's the Ministry of Foreign Affairs that contacts the organization that is hosting the treaty. So there it would be us in Strasbourg, expressing the intention to accede. And then you have the normal machine starting, which is that there is bilateral discussion with South Africa. We're checking the law. We're seeing if it matches the provisions of the convention, because clearly that's the objective. And then it depends on national and domestic peculiarities about the ratification process, but that's normally how it's done. The Ministry of Foreign Affairs expressing an interest, and then an informal invitation being sent to accede. So not really difficult. About the question of the pace of technological change, yes, I think it's the traditional dilemma of lawmakers is that it takes time to make law, and by the time you've enacted the law and it's applied, sometimes it's outdated. But it depends how you draft the law, actually. If you don't make any reference to any particular technology, your principles stand the test of time. And the best example I can give you is Convention 108. It's a 40-year-old instrument. If you look at the definition of personal data, it's still the definition that is used today in most of the legislations, because it was drafted in an open manner without any restrictions and reference to particular types of identification of the person, for instance. Same thing with processing. If you keep it as a closed definition of a series of actions on the data, then you're doomed, because there will always be new ways of processing data. So actually, the drafters of the convention did a really great job, because 40 years later, it's still absolutely valid. There is nothing that is obsolete, but definitely we needed to tackle some of the new challenges, because it was thought and it was meant at a time when internet did not exist. So we've been reinforcing it, but we've been very cautious in the modernized text in 108 plus, not to refer to any specific technologies. I mean, you will not see cloud, you will not see blockchain or whatever, because otherwise the text would have been outdated at the time we were enacting it in 2018.
I see there's a further question there from Advocate Lufuno Chikalange. The question is, what strategies does the European Council use to ensure enforcement mechanisms? And then also looking at the lack of ratification of the Malabar Convention, what seems to be the problem with African states not to commit to data privacy or protection?
Yeah, thank you. Very good question. So, and it's actually one slide I normally have, but because my time was limited, I did not touch upon that. But this whole system of trust and reciprocity only works if the commitments that are taken are actually respected. And this is unfortunately one of the big lacunas of the original text of 1981. There is no compliance check, no monitoring of what the countries are doing. And it's an issue because then you cannot, trust that you can export data to country X or Y because you actually have heard that there's something going on in this country that is not ideal in that respect, but it's not evidenced. And so with the modernized convention, with 108 plus, it's also one of the key added values of the convention. There will be a monitoring in place, and we can go and we can check compliance, and you can check that the signatories live up to their commitments. That's the only way to secure the credibility of the principle of free flow of data. And then about the Malabo Convention, and indeed there hasn't been such a take-up at African level. I think it's a matter of time actually, because we see that the legislative developments now, the pace in Africa is immense, and clearly the topics you'll be dealing about the economic benefits and digitalization of our societies. This is sorely bringing behind the need for a strong data protection. And then when countries enacting this legislation, starting to enforce it with the means that is necessary, will have to come to the Malabo Convention. And then I don't know if the difficulty is also because the Malabo Convention has this dual part, one on data protection, one on cybersecurity. I don't know if it's one of the issues that led to the fact that it was not taken as rapidly as it could have been.
Thank you very much there, Sophie. Like I said, we were very honored
Welcome.
to have you.
My pleasure.
Opening our conference and giving us the European perspective. Earlier on, my co-chair couldn't connect. Judge Chawki, are you there now?
I am here, Professor Snail.
Thank you, Judge. Over to you.
Thank you, Professor Snail. Good morning, everybody, and welcome to Lex-Informatica 2020 conference. Sorry, I had a connection problem. I couldn't join you in the opening. On behalf of Snail attorneys in South Africa and the board members of the International Association of Cybercrime Prevention, located in Paris, I would like to welcome you today in our webinar. I would like to express my gratitude to Professor Sizwe Snail and the Council of Europe and all other African and international institutions that took part in the organization of this event. For those of you who don't know, our association is a profit organization established according to French law and located in Paris. I have been elected several times as a chairman of this organization. The main target of the association is to increase the awareness against cybercrime by the organization of workshops and seminars worldwide and by conducting research in the area of cyber law. Since the creation of the association in 2006, we have organized more than 100 conferences and workshops. We have organized or co-organized conferences in South Africa in cooperation with Snail attorneys, in Lebanon, United Arab Emirates, Egypt, France, Malaysia, Australia, Morocco, Brazil, United States of America, and India. We have international chapters to increase the awareness against cybercrime. We currently have chapters in Australia, Brazil, Morocco, Lebanon, and the South African chapter is chaired by Professor Sizwe Snail. We also have a team of volunteers who is very highly qualified and help cybercrime victims. Are a victim, and our team of volunteers will advise you and help you for free. You just access site and fill in the application form. In our association, if you are interested in the field of cyber law and cybercrime, or you to engage in the public work or join of volunteers, please complete the online application form that will be examined by the board members before we give a response. Again, I would like to thank the co-organizers, the speakers, and the participants today, and wish you all an excellent webinar. Thank you.
Thank you for that, Judge Chawki. Yes, like I said, once again, we have actually managed to assemble everyone to this event, which I said now has been taking place for the last 12 years. You will, for those of you who have been attending this conference for a while, you will remember that Judge Chawki actually came down to South Africa, and we had a very, very big conference at Monte Casino. It was most interesting, and as a spring of that event, we created the ACCP, and the ACCP is the African Center for Cyber Law and Cybercrime Prevention, based in Kampala, of which Judge Chawki once again is the co-director of that, as well as the outgoing director, Mr. Sambasita of UNAFRI. We do intend to develop the center further, and we are looking for a new home for the center in due course. With that having been said,